Ever feel like the legal system is speaking a foreign language?
Uh-huh. I know what you mean.
Like you need subtitles just to understand what's going on.
Yeah, it could definitely feel that way sometimes.
Well, today we're tackling civil procedure, think lawsuits, not criminal trials, and we've got our expert here to break it all down.
That's right. We're diving deep into a set of 50 civil procedure Q&As, kind of like a cheat sheet for navigating the legal world.
No law degree required.
Definitely not.
Because let's be honest, whether you're dealing with a contract dispute, a fender bender, or just trying to understand the news, this stuff comes up more than you might think.
It really does. And having even a basic understanding of these concepts can be so empowering.
Absolutely. So let's jump right in with that sounds a lot more intimidating than it actually is: personal jurisdiction.
Okay, personal jurisdiction.
It's all about whether a court has the power to hear a case involving a specific person or entity.
Exactly. It's like setting the boundaries for a legal boxing match. The court needs to make sure it has the authority to even bring the fighters into the ring, so to speak.
So let's say I have a disagreement with someone who lives clear across the country. I can't just sue them in my local small claims court, right?
Yeah, probably not. And that's where the concept of minimum contacts comes in. This principle, which was established by a landmark case called International Shoe, basically means that the defendant needs to have some meaningful connection to the state where the lawsuit is filed.
Okay, so what qualifies as a meaningful connection? Like just visiting the state for a weekend wouldn't count, would it?
Probably not. But think of it this way. If you run a business in a state, or you have an office there, or you sell products that directly impact people in that state, then you've established a connection that could subject you to their courts.
So it's not just about physical presence, it's about the impact of your actions. Right?
Exactly.
Hmm.
Let's say you have an online store that's based in California, and you sell a faulty product that injures someone in Texas.
Mm-hmm.
Even though you've never set foot in Texas, that injured consumer could potentially sue you there because your business activity directly impacted them in Texas.
That makes a lot of sense. It's about accountability, making sure that people can't just evade responsibility by being physically located elsewhere.
Exactly. And to enforce that accountability, we have something called long-arm statutes.
Long-arm statutes, okay.
Yeah. These statutes give courts the power to reach across state lines and pull someone into court, even if they don't reside there.
So it's like a legal lasso that can wrangle someone back to face the music, even if they're trying to skip town.
You got it. Think of a hit-and-run accident, for example. If the driver flees to another state, the victim can still use the long-arm statute to try to hold them accountable in the state where the accident actually occurred.
That's reassuring to know. So we've got personal jurisdiction, which focuses on who the court has power over, but then there's subject matter jurisdiction, which is all about what types of cases a court can even hear, right?
Right. It's like going to a specialist doctor. You wouldn't go to a cardiologist for a broken bone, right?
Right.
Courts have specialties too.
Okay, so walk us through the different types of courts. What are the main players in this legal drama?
So in the U.S., we have two main court systems. We've got federal courts and state courts. Federal courts handle cases involving federal law, things like constitutional issues, or disputes between parties from different states when there's a significant amount of money at stake. We call that diversity jurisdiction.
So if I get in a fender bender with someone from another state, that wouldn't necessarily end up in federal court unless the damage is, like, really serious.
Exactly. Most everyday disputes like car accidents, contract breaches, personal injury cases, those are usually handled in state courts. They're kind of the workhorses of the legal system.
It sounds like federal courts are reserved for the more complex, high-stakes legal battles. So how do they actually decide which cases go where? Is it a coin toss?
Not quite. It all starts with the plaintiff, the person who's filing the lawsuit. They have to clearly state in their initial complaint why the chosen court has the authority to hear their case.
Oh, I bet that gets strategic.
It does. It's like choosing your battleground carefully. And there are specific rules about how this has to be done.
Oh, okay.
There's a legal principle called the well-pleaded complaint rule, which essentially means that if you're trying to get your case into federal court based on a question of federal law, you have to make that crystal clear from the get-go. You can't just kind of sneak it in later.
So no legal curveballs allowed. You got to lay your cards on the table up front.
Exactly.
Seems like a lot can hinge on these initial filings.
Absolutely. These procedural rules are there for a reason. They ensure fairness and prevent cases from getting bogged down in technicalities. But there are also situations where even if a court could hear a case, it might decide it's just not worth its time.
Okay, that's where justiciability comes into play.
Yes, exactly.
When a case might be deemed, like, not worth the court's time. Can you give us an example?
Yeah, so imagine a couple battling it out in court over who gets the dog in a divorce settlement. But then, sadly, the dog passes away while the case is pending. Well, that case would become moot. There's no point in the court wasting time and resources on an issue that no longer exists.
It's like showing up to a pie-eating contest only to find out all the pie is gone.
Exactly.
Makes sense.
And just like you wouldn't enter a pie-eating contest if you didn't plan to eat any pie, you can't just sue anyone over anything. You need to have something called standing.
Okay, so standing is all about having a dog in the fight, so to speak.
Precisely. You need to be directly affected by the issue at hand and have a genuine stake in the outcome of the case. For example, you can't sue a corporation for polluting a river in another state if you haven't personally suffered any harm as a result.
That makes sense. Prevents people from filing lawsuits for issues that don't actually impact them.
Right. And then there's ripeness. You can't sue someone based on something you think they might do in the future. The issue has to be a present problem, not just a hypothetical one.
So no suing your neighbor because you think they might cut down that tree that's technically on your property line, at least not until they actually start chopping.
Right.
Okay, but what happens when the case itself isn't about a person, but about a thing, like property?
That's where we delve into the world of in rem jurisdiction.
In rem jurisdiction,
Yeah,
okay.
it's all about the court's power over a specific piece of property located within its geographical boundaries.
So if two siblings are fighting over ownership of their late parents' house, the court in the same state as that house would have jurisdiction?
Exactly. The house itself becomes the focal point of the legal battle.
Yeah.
But it can get even more complex with quasi-in rem jurisdiction.
Okay, quasi and rem jurisdiction. Now we're really getting into the legal weeds.
I know, right?
Break it down for us.
Imagine this. Someone owes a significant debt, and they own property in a different state. A creditor might try to use that property as leverage to collect the debt, even if they can't actually track down the debtor personally.
So it's like using the property as bait to lure the debtor out of hiding.
In a way, yes. It allows the court to indirectly exercise power over a person through their assets.
That sounds like a powerful tool. But what about the debtor? Doesn't fairness come into play somewhere in all of this?
You've hit on a crucial point. The legal system is bound by the principle of procedural due process,
Procedural due process.
which essentially means everyone deserves a fair shot at presenting their case.
Okay, good. Glad to hear that fairness is baked into the system. So how does due process actually work in practice?
Well, a key aspect of due process is proper notice. You can't just spring a lawsuit on someone out of nowhere without giving them a heads up and a chance to respond. That wouldn't be fair, would it?
Not at all. So what counts as proper notice? Is a text message enough these days?
That's a great question, and it's something courts have actually grappled with as technology has evolved. There's a landmark case, Mullane v. Central Hanover Bank and Trust Company, that really clarified what constitutes adequate notice.
Okay, tell us more about this Mullane case. What happened?
This case involved a bank trying to notify beneficiaries of a common trust fund about a settlement,
Okay.
and they opted to publish a notice in a local newspaper as, a cost-effective way to reach everyone.
Wait, publishing it in a newspaper? How would anyone even know to look for it?
Exactly, and the Supreme Court agreed. The Mullane case established this crucial precedent notice has to be reasonably calculated to actually reach the interested parties.
So it's not just about making good faith effort, it's about being strategic and using methods that are actually likely to get to the people who need to know.
Exactly. In today's world, that might mean email, certified mail, maybe even social media, depending on the circumstances. The key is to ensure that the notice is reliable and accessible.
Sounds like common sense, but sometimes you need the law to spell it out. So let's say a court does have jurisdiction and everyone's been properly notified. What's next in this legal obstacle course?
Well, that's where we get into the nitty-gritty of venue.
Venue, okay.
Yeah, figuring out which specific court within a jurisdiction is the most appropriate place for the case to actually be heard.
So it's like finding the right courtroom for the legal showdown.
Exactly. And it's not just about geography either. It's about fairness, practicality, thinking about witnesses, evidence, the convenience of all the parties involved. It wouldn't make sense to have a trial hundreds of miles away if everyone involved lives and works in the same town.
Definitely not. It's like choosing the right size pot for your pasta. You don't want it boiling over.
Exactly.
So once the venue is sorted, how does a lawsuit actually start taking shape? What are the opening moves in this legal chess match?
That's where pleadings come in. Think of them as the opening arguments, setting the stage for the entire legal battle.
Sounds dramatic. Is it anything like what we see in courtroom dramas? Do lawyers actually slam their hands on tables and shout objections?
Well, it's usually a bit less theatrical than that, but you're right, it is all about laying out the groundwork. The plaintiff files their complaint, outlining their grievances and what they want. The defendant then files an answer, responding to those claims.
And I'm guessing there are rules about what you can and can't say in these documents?
You bet. This is where things can get a bit technical. There's a whole section in the Federal Rules of Civil Procedure dedicated to this Rule 8A.
Rule 8A.
It mandates that a complaint must be clear, concise, and include specific elements, like the grounds for the court's jurisdiction and a clear demand for relief.
So no rambling legal jargon or Shakespearean monologues allowed.
Not if you want to make the judge happy. Clarity and conciseness are key. And when it comes to specific types of claims, like fraud, things get even more detailed.
Oh. What happens then?
Well, Rule 9b comes into play. This rule requires that when you're alleging fraud, you have to provide specific details, dates, times, parties involved, the specific statements or actions that constitute fraud.
So you can't just throw around accusations of fraud without backing them up with concrete evidence.
Exactly. It's about preventing vague accusations and ensuring that the defendant has a fair chance to actually defend themselves. But what if the defendant believes the case is completely baseless?
Then what? Do they just have to go along with it?
Not necessarily. They have a powerful tool at their disposal, the motion to dismiss.
So it's like saying, hold on a minute, this is completely ridiculous. Let's just end this here and now.
Precisely. Rule 12b-6 allows a defendant to file a motion to dismiss for failure to state a claim upon which relief can be granted.
Okay, that's a mouthful. What does that mean in plain English?
Basically, they're arguing that even if everything the plaintiff claims is true, it still doesn't add up to a valid legal claim.
So it's a way to potentially stop a lawsuit dead in its tracks before it even really gets going.
Exactly. It's a crucial tool for defending against frivolous lawsuits and making sure that the court's time and resources are being used efficiently.
It seems like a lot can happen in those early stages of a lawsuit. But what happens when things get more complicated? For example, if there are multiple parties involved or several interconnected claims, that's where things can get really messy, right?
You're right, it can get messy, and that's where Joinder comes in. Essentially, it's the process of combining claims or parties into a single lawsuit.
So instead of having multiple lawsuits playing out like separate episodes, you can bundle them together into a single legal miniseries.
You got it. And believe it or not, there's a method to this madness.
I'm all ears. Tell us more about this Joinder thing.
Imagine a multi-car pileup on a busy highway.
Okay, I can picture it, a real fender-bender extravaganza.
Now let's say several people are injured, and they decide to sue the driver who caused the accident. Instead of having each injured person file separate lawsuits, they can potentially join forces and bring one single lawsuit against that at-fault driver.
So it's like a legal carpool lane, more efficient and less congested.
You got it, and that's what we call permissive joinder. Rule 20 allows this type of legal teamwork when the claims arise from the same incident and share common legal questions.
It sounds like a strategic move for the plaintiffs too, strength in numbers.
Absolutely. But it can also work the other way around. Let's say in our pileup scenario, there's a question about whether a mechanical failure contributed to the accident. The at-fault driver might try to bring the car manufacturer into the lawsuit as an additional defendant.
So instead of one big legal battle, you might end up with an even bigger legal battle royale.
It can definitely get complex. And then there are situations where joining parties isn't optional. It's legally required.
Okay, when would that happen?
Imagine you're dealing with a dispute over a piece of property that has multiple owners, like a family inheritance. To ensure a fair and complete resolution, the court might require that all the owners be joined as parties in the lawsuit.
So everyone with a stake in the outcome has to be present at the table. Makes sense. But what about those curveball moments when someone involved in a lawsuit tries to bring up a completely unrelated issue, maybe even against the person who sued them in the first place? Is that even allowed?
It can be. That's where counterclaims come into play.
Okay, tell us more about this legal maneuvering.
Imagine you're being sued for, say, unpaid rent, but you believe your landlord actually owes you money for failing to fix that leaky roof, as promised in your lease agreement. You could bring your own claim for damages against the landlord as part of the same lawsuit.
So it's like a legal, you can't fire me, I quit.
Exactly. It can
Right.
turn the tables in a lawsuit, and there are different types of counterclaims. A compulsory counterclaim arises directly from the same events as the original claim, like our rent and leaky roof scenario.
So it's not just some random grievance you can throw in there to muddy the water?
Right? A compulsory counterclaim is directly related to the heart of the matter. But then there are permissive counterclaims,
Yeah.
essentially separate lawsuits that the defendant could have filed independently, but they choose to bring it up as part of the existing case for convenience.
Got it. So it's a way to streamline things and potentially resolve multiple issues in one go. It sounds like strategy is just as important as the actual facts of the case. But no matter how much legal maneuvering happens, don't you eventually need evidence to back up your claims?
You're absolutely right. All the legal tactics in the world won't win a case without solid evidence,
Yeah.
and that's where discovery comes in.
Okay, this sounds juicy. Is it anything like what we see in spy movies, secret surveillance, and hidden microphones?
Well, it might not be as glamorous as a Hollywood thriller, but it's definitely a crucial part of the legal process. Discovery is all about gathering information and evidence to build your case, and it's surprisingly organized considering how much is at stake.
So, how does it work? Do lawyers just get to go on wild goose chases and demand any document they want?
Not quite. There are rules in place to ensure fairness. One common method of discovery is the deposition.
Okay, I've definitely heard that term thrown around, but what actually happens in a deposition?
Imagine this. You walk into a room with your lawyer. Seated across from you is the opposing party with their lawyer, and there's a court reporter diligently documenting every word that's spoken. It's all very official, and you're sworn in under oath, just like you would be in a courtroom.
Okay, I'm feeling a little nervous just picturing it. What happens next?
The questioning begins, and unlike in court where you often hear those rapid-fire yes or no questions, a deposition allows for more open-ended questions. It's an opportunity to delve deeper into the other party's story, get their side of events on record, and look for any inconsistencies or new pieces of information that might help your case.
It sounds like a legal game of chess where you're trying to anticipate the other player's moves and gather as much intel as possible.
Exactly. And depositions can be incredibly valuable. They allow you to see how credible the other side's witnesses are and how well they hold up under pressure. Plus, anything said in a deposition can be used later on in court.
Wow, the stakes are high, but depositions aren't the only tool in the discovery toolbox, are they? What else do lawyers have up their sleeves?
Another common one is interrogatories.
Interrogatories. That sounds serious.
It sounds more intimidating than it actually is. Think of interrogatories as written depositions. One party sends a set of written questions to the other party, and those questions have to be answered truthfully and to the best of their ability.
So it's a way to get information directly from the source, but in writing, which can sometimes be less confrontational than a face-to-face deposition.
Precisely, interrogatories are great for gathering factual information, like names of witnesses, dates of events, or descriptions of documents.
It sounds like discovery is all about leaving no stone unturned, but at a certain point, things have to move toward an actual trial, right? Or do they?
You're right, the legal clock is always ticking. And while many cases do end up going to trial, there's a way to potentially end things early summary judgment.
So it's like a legal shortcut?
In a way, yes. If there are no genuine disputes about the key facts of the case, meaning everyone agrees on what essentially happened, then the court can sometimes apply the law to those facts and make a decision without a full-blown trial.
So if it's clear who's in the right, the court can just cut to the chase and issue a ruling.
Exactly. It's about judicial efficiency. Why waste time and resources on a trial if the outcome is already clear-cut?
Makes sense. Now, we've been talking about individual lawsuits, but what about those massive cases we sometimes hear about in the news, the ones involving thousands of people? How do those work?
You're talking about class actions, a fascinating and sometimes controversial aspect of the legal system.
Okay, give us the lowdown on class action lawsuits.
Imagine a situation where a company releases a faulty product that harms thousands of consumers across the country.
Like that exploding smartphone debacle a few years back.
Exactly. Instead of each individual filing their own separate lawsuit, which would overwhelm the courts. Rule 23 allows for a class action to be filed. This means a small group of representative plaintiffs can sue on behalf of the entire group, known as the class.
So it's like a legal Avengers Assemble moment with a few brave souls fighting on behalf of the many.
Exactly. It allows individuals to pool their resources and collectively take on powerful corporations. It's all about leveling the playing field.
That's impressive, but are there specific rules about when a class action lawsuit can be filed? It can't just be any group of people with a shared grievance, can it?
You're right, there are safeguards in place to prevent frivolous class actions. Rule 23A outlines 4 key requirements. First, there's numerosity. The class has to be so large that joining everyone as individual plaintiffs would be logistically impossible.
So no class action lawsuits for a disgruntled book club.
Probably not, unless that book club has thousands of members, then there's commonality.
Yeah.
There must be common questions of law or fact
Yeah.
that apply to everyone in the class.
So in our exploding smartphone example, everyone would have suffered harm due to the same design flaw in the phone.
Exactly. The third requirement is typicality. The claims of the representative plaintiffs must be similar enough to the claims of the entire class to ensure they're a good fit for the group they're representing.
It's about making sure the chosen representatives are truly representative of the larger group. What's the final requirement?
The last requirement is adequacy of representation. The lawyers representing the class must be competent and experienced enough to handle a complex case of that magnitude.
It sounds like a lot of boxes to check, but it makes sense that there are safeguards in place to prevent abuse of the system, now shifting gears a bit. I'm curious about how the legal system prevents people from dragging out the same legal battle over and over again.
That's where claim preclusion and issue preclusion come into play. They're all about ensuring finality in legal disputes.
So no legal sequels or reboots.
Precisely. Claim preclusion, also known as res judicata, prevents a party from relitigating a claim that's already been decided by a court.
So if you sue someone for breach of contract and you lose, you can't just turn around and sue them again for the same breach.
Exactly. It prevents harassment through repetitive lawsuits and brings a sense of finality to legal disputes. Issue preclusion or collateral estoppel is a bit different.
Okay, what's the difference?
It prevents a party from relitigating a specific issue that's already been decided in a previous lawsuit, even if the two lawsuits are based on different claims.
Can you give us an example? This feels a bit like legal gymnastics.
Let's say you're injured in a car accident and you sue the other driver for negligence. The court finds that you were 20% at fault for the accident because you weren't wearing your seatbelt.
Okay, I'm following so far.
Now, let's say you later decide to sue the car manufacturer, claiming a defect in the car also contributed to the accident.
Oh, okay, I see where this is going.
Because the issue of your own negligence in the accident has already been decided in the first lawsuit, that 20% fault assigned to you, you wouldn't be able to argue that you were blameless in the lawsuit against the car manufacturer.
So it prevents you from having a do-over and potentially getting a different outcome on the same issue. It keeps things consistent.
Exactly. It ensures that once an issue has been decided by a court, it's settled, preventing conflicting rulings and endless litigation.
Makes sense. Now we've covered a lot of ground here, from the initial stages of a lawsuit to all the twists and turns a case can take. But at the end of the day, many of these cases end up in front of a jury. What role do they play in this whole legal drama?
Juries play an absolutely essential role in our legal system. They embody the principle of judgment by one's peers, ordinary citizens tasked with the weighty responsibility of hearing evidence and rendering a verdict.
So it's like real people stepping into the legal arena.
Exactly. And it's not just about showing up. It's about ensuring fairness
Yeah.
and representing the community in the justice system.
Hmm.
The selection process is rigorous too, designed to weed out any potential biases or conflicts of interest.
Okay, walk us through how a jury is chosen. How do they find these brave souls willing to serve?
It all starts with a pool of potential jurors being summoned to court. This pool is typically randomly selected from lists like voter registrations or driver's licenses.
So you never know when that jury duty summons might show up in your mailbox.
Exactly. Once the potential jurors are gathered, they go through a process called voir dire.
Voir dire. This sounds pretty official.
It's French for to speak the truth, and it's essentially the jury selection process. Lawyers from both sides get to question potential jurors to make sure they can be fair and impartial. They're looking for any red flags that might suggest a juror can't be objective. Prior knowledge of the case, strong opinions about the parties involved, or any personal experiences that might cloud their judgment.
So it's like a combination of a job interview and speed dating, but for jury duty.
You could say that it's a delicate balance of legal strategy and ensuring a fair trial.
It sounds fascinating. Now let's say you make it through the voir dire process and are chosen for the jury. What exactly is your role once the trial begins?
The jury's primary responsibility is to listen carefully to all the evidence presented. Witness testimonies, documents, expert opinions. They're the ultimate finders of fact.
So they're like detectives piecing together the truth based on the clues presented in court.
Exactly. They have to disregard anything they've heard about the case outside the courtroom, like news reports or social media posts, and focus solely on the evidence presented during the trial. Once all the evidence is in, the judge explains the relevant law and then it's up to the jury to deliberate in secret and reach a verdict.
No pressure or anything. What standard of proof do juries use in civil cases? Is it the same beyond a reasonable doubt standard we hear about in criminal cases?
That's a great question. In civil cases, the standard of proof is preponderance of the evidence.
Okay, break that down for us. What does preponderance of the evidence actually mean?
It essentially means more likely than not. So the jury has to decide, based on the evidence presented, whether it's more likely than not that the defendant is liable for the harm alleged by the plaintiff.
It's a lower standard of proof than the beyond a reasonable doubt used in criminal cases, which makes sense, since the consequences of a civil case are usually financial, not jail time.
You've got it. And while juries play a crucial role in ensuring justice is served, they're not the only ones bound by legal precedent. Courts themselves have to follow precedent to maintain consistency and fairness.
That's where stare decisis comes in, right? The idea that courts should generally stick to established legal principles.
Exactly. It's Latin for to stand by things decided, and it's a fundamental principle of our common law system.
So it's like a legal playbook helping courts navigate new legal challenges while still adhering to established rules.
It promotes predictability and stability, ensuring that similar cases are decided in a similar manner. But what happens when laws from different states collide?
That's a great question. We've been talking about federal and state courts, but what happens when you have a lawsuit that crosses state lines whose laws went out?
You're entering the fascinating world of conflict of laws, a complex area of law that addresses exactly that.
Okay, this sounds like a recipe for legal chaos. Give us an example of when a conflict of laws might come up.
Imagine a contract dispute between two businesses located in different states. Each state might have different laws governing contracts, leading to a legal tug of war.
So how do courts untangle this jurisdictional knot? Do they throw darts at a map?
Not quite. Courts have developed various approaches to tackle this, but one common method is the most significant relationship test.
Okay, tell us more about this test. How does it work?
Essentially, the court carefully analyzes the facts of the case, where the events occurred, where the parties reside, where the contract was signed, and other relevant factors to figure out which state has the most significant ties to the dispute.
So it's about figuring out which state has the most skin in the game, so to speak.
Exactly. The goal is to apply the law that has the most meaningful connection to the case. And speaking of laws, we've mentioned various rules and statutes throughout our conversation, but it makes me wonder, where do all these rules come from and how do they impact the legal system?
It really feels like we've just zoomed through a law school semester in the span of like an hour,
Right.
but hopefully in a fun way.
Definitely.
So we've demystified some of that tricky legal jargon. We've gone behind the scenes of how these courtroom showdowns actually work. And most importantly, hopefully our listeners are walking away feeling more equipped to navigate the legal world.
Exactly. We've only just dipped our toes into the vast ocean of civil procedure. But hopefully you've gained some practical insights that you can actually use.
Absolutely, because whether you're reviewing a contract, dealing with a dispute, or just trying to follow along with those headline-grabbing legal battles, this stuff is surprisingly relevant to all of us.
It really is.
Yeah.
And knowledge is power, right? Understanding these concepts can give you a sense of confidence and control, even when you're dealing with a tricky legal situation.
Absolutely. It's like having that secret decoder ring to decipher what can often feel like a foreign language.
Exactly. And remember, this is just the beginning of your legal journey. There are so many resources out there to help you learn more, legal blogs and websites, podcasts just like this one, even online courses if you want to really dive in deep.
And hey, if you're ever wrestling with a legal question or a scenario that has you stumped, we're all ears. We love a good legal puzzle.
Absolutely. Send us your questions, your thoughts, your legal conundrums. We're here to help make sense of it all.
Because at the end of the day, the law, as complex as it can be, really is designed to protect our rights, to resolve disputes fairly, and to ensure justice prevails. And we believe that everyone should have the tools and knowledge to navigate this system effectively.
Couldn't agree more.
So that's a wrap on our deep dive into the world of civil procedure. Hopefully you're walking away feeling empowered, informed, and maybe even a little bit excited about the law. Until next time, stay curious, stay informed, and most importantly, stay out of trouble.
Haha. Easier said than done sometimes, but great advice nonetheless.